So we called to order for our executive session today, 7 p.m. And with that, we have a temporary secretary for today's session, Joe Brungart. If you are ready, would you please proceed with a roll call?
Please give me 1 second so I can maybe do
No
this
problem.
in a more organized fashion.
No problem, thank you.
All right, Andrew Chatterton,
Present.
Dan Zamba, Norm Peterson. I see you, Norm.
His mic's not working.
Okay. Ryan Roberts.
Present.
Thank you, Ryan. Stephen Fox said he wouldn't be here. Jordan Martin.
Yeah.
Rick Thielen. Dave Canny.
Here.
Brian Ellison.
Joe for chair.
Is Joe Hartman resigned officially? I guess he's not here anyway. Doesn't matter. Mike Saliba.
Hi.
Joe Brungart is here. Bruce Jakeways.
Here.
Thanks, Bruce. Daniel Muehlmiller. Paul. Okay, and we don't have guests because it's an executive session. So,
We do, however, though.
oh, one special guest that approved. Sorry, Mr. Doster, for saying you're not a guest.
Let's give a moment. Can you give a tabulation of the total LEC members present?
Yes. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Out of, I believe,
13.
13 total.
Yep. All right. So thank you very much. So that'll be 6 votes for a majority decision. All right. So I will bring up the agenda. Pretty simple one today. So we have call to order, roll call, paperwork check, which consists of the agenda, followed by question and answer period with Mr. Eric Doster, speak to the questions from the parliamentarian and from board members. And then reconsideration of the motions from the previous meeting after the discussion today for consideration of hiring Mr. Doster and Mr. Britton, followed by adjournment. Anybody have any questions or discussion of the agenda prior to approving the minutes?
I do.
Okay, go ahead.
I would like to make a motion to amend the agenda to remove the item regarding the motion of for the parliamentarian as being disposed of last week.
Okay, do we have a second? Okay, is there discussion of the motion?
I'll be real brief. I mean, we talked about it last week. Not a single member of this body spoke in favor of it, and it was overwhelmingly rejected. So I feel like bringing it back up is essentially dilatory.
Is there any other argument?
No, I agree.
All right, hearing no more arguments, is there any, can we go to a vote? All those in favor of the amendment, please say aye.
Aye.
Hi.
Any opposed?
No.
No.
I believe the ayes have it. Okay, we will return now to the main consideration to consider the agenda. Is there any further discussion?
I have a point of parliamentary inquiry. I believe that we need to discuss our process or a proposed process for this question and answer period. Unless the chair has something in mind, and I guess that's my question.
That would not be relevant to the discussion of the agenda. You can bring that up after we.
It's relevant if it needs to be added to the agenda, which would be my proposal, that we would insert that as item 4 to discuss and approve a method for handling the question and answer period.
Okay. Is there a second to that motion?
Second.
Okay, we can open for discussion.
Over question.
Okay, can I get a clarification on specifically what the item should be?
Yeah, it would be a establishment of procedure for question and answer period.
Okay. All right, question has been called. Is there any opposed? Hearing no opposition, we can move to the vote. All those in favor, say aye.
All right.
Aye.
Opposed, say nay. Okay, the motion is passed. Any further discussion on the agenda?
Mr. Chair,
Yes.
move to adopt the agenda as amended.
Second.
Okay. All right, we can move forward to the vote then. All opposed to adopting the agenda as amended? Say aye.
Aye.
Any opposed, say nay. Okay, the agenda is adopted. With that, we'll move to our next item of business, establishing a procedure. And the floor is open. See Mr. Ellison raising his hand.
Yeah, so I had proposed this on Discord and got a little bit of feedback, but my proposal would be that we allot a block of time per member. And I liken it to how they conduct the congressional hearings where a member of the body is given a block of time to ask questions and follow-up questions of Mr. Doster. So I would form that as a motion, and based on the fact that we have 10 members, and I think there's no reason to say we can't put a 10-minute time limit per member, and I doubt most of us will use that full time period. But I would move to adopt a procedure where each member of the committee is allotted 10 continuous minutes for questions and answers with Mr. Doster in an order to be determined by the secretary through the roll call vote order.
Mr. Secretary, did you catch all that?
Yeah, Mr. Ellison is moving to adopt a 10-minute time limit per board member for question and answer session with Mr. Doster in an order to be chosen by me.
All right, can we confirm, one second. So I wanted to, go ahead, Mr. Canning.
I'd like to amend that motion as to our question period would start after Mr. Doster's statements. And then the questions that Andrew had submitted, let those go first and then our questions would follow.
Second.
Okay, so Dave, do you propose to amend that by substitution then?
No, just that it would take, Brian's point would stand, Brian's motion would stand. It would just, our question period would follow Mr. Doster's statement and Andrew's initial questions that were submitted.
Okay, let me try and capture that. I am really gaining a lot of respect for Daniel right now.
Well, if you're trying to write the way I speak, you're in trouble.
Okay, so what I have here is the, if amended per Mr. Canny, the motion would read that we're limiting 10 minutes per board member for Q&A with Mr. Doster after Mr. Doster is allowed an introduction time and the questions documented by Mr. Chatterton have been asked. Is that accurate, Dave?
Yes, thank you.
I have a point of inquiry, and I suppose it's actually for Mr. Doster. Is Mr. Doster, for you to go through those questions and kind of summarize what you've already worked on, how much time do you think you need?
Well, what I had anticipated was to going through and basically giving this body kind of an overall my findings to date. And, that would probably take maybe 10 minutes, 5-10 minutes. And then to the extent then I could go back and look at the questions that were previously supplied to me. And if you board members have additional questions that I can answer based on what I've already looked at, I'll happily answer them.
Thank you.
But that sounds consistent with where you guys are all going. So I think we're all on the same page.
I
Can I ask, Mr. Doster, for the preparation of the meeting, did it require any time to, get prepared for that as?
Oh, hell, I've blown past my 2 hours, but I'm gonna cap it at 2 hours.
Okay.
I've looked at a hell of a lot more than 2 hours worth, to be blunt. But I'll cap this all at 2 hours for tonight.
Appreciate it. All right, so I believe we are kind of through the preliminary stuff. We are having, I think, the motion of establishing that format on the floor has been amended. And are we ready to vote on that? Is there any further discussion of that method before we lock that in? All right, hearing none, we will go to a vote on, I believe the amendment is where we stand. So we're looking at Mr. Kenny's amendment. Mr. Brungart, would you mind to state that once more before we go to the vote?
Yes, if amended, the motion would read in whole that we're setting a limit of 10 minutes per board member for Q&A. And in order to be chosen by the secretary after Mr. Doster's introduction and questions submitted by Mr. Chatterton have been answered.
Okay. So we are taking the amendment, which is all of that except for the initial motion of the 10 minutes. So all the ed content is what we were voting on. So all those in favor of the amendment, please say aye.
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 And all opposed, say nay. Hearing none, the amendment is passed. Do we have any further discussion on the main motion before we move to a vote? Hearing none, go to another vote. Now on the main motion to establish the 10-minute procedure with, as just stated. All in favor of that motion to establish the procedure, please say aye.
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 Any opposed, please say nay. All right, hearing none, that will be passed and will serve as our procedure for the Q&A. So now we can move into our Q&A. I believe that was intended for Mr. Doster to start with his initial statements and then go to the Q&A afterwards. Mr. Doster.
Well, good evening. Before I start, I was over 25 years as general counsel of the Michigan Republicans, so I understand, when you get in bodies like that, there's like a lot of push me and pull me to get the council to rule X, Y, or Z. But I guess the first thing I wanted to throw out there was no one has asked me or suggested that I find X, Y, or Z. The materials that I've been given the communications were emails, essentially. And so I think the board, at least one of the things I've seen was shared with the board. So, basically what I've looked at and what I've been given. And so there's going to be some knowledge gaps that I'm not aware, like I'm not aware of notice requirements for your EC meetings or even notice requirements for conventions. I don't have that. I wasn't given that, and that's fine. But so I wanted to throw that out there right up front because I've been played push me, pull me for many decades. So I just want to let you know that I'm just looking at this stuff as an outsider's perspective, and I'm going to tell you what I've looked at. The authority that I've looked at, your LPM bylaws, which incorporate Robert's rules, and I've already heard some Robert's rules discussions this evening. Then you've got your corporate bylaws, because LPM is incorporated under the Michigan Nonprofit Corporation Act, but your corporate bylaws basically defer to your LPM bylaws. So they don't add a heck of a lot to the discussion. And then there's the Michigan Nonprofit Corporation Act that I've looked at. We've got two things going on. We've got resignations, and now we have some subsequent vacancies. Now, based on what I saw, I saw the resignation of the chair, and there was somebody else. Was he what was his position?
That was a vice chair, I believe. Yeah,
Was he a second vice chair?
First vice
He
chair.
was a first vice chair. Okay. And then, but then you've got a 19-member EC, so you're light 6. Where'd the other 4 come from?
Those were coming from resignation among district representatives that happened at approximately the same time, and then a couple that happened at different times.
Okay, so we've got 4 district reps and then
Correct.
2 officers. Okay, thank you. With respect to resignations, I'll start with resignations first. My observations, the LPM bylaws, basically go up the food chain. so it looks like we had a chair and a first vice chair resign. So then, section 3, or however you call them, articles or sections, I guess I'll call it article. Article 3, section 6 says that will assume the duties, perform the duties of the first vice chair in the absence of the chair. In the absence of the chair and the first vice chair, that goes up the line and that person becomes the chair. Since we no longer have a first vice chair. So whoever was the second vice chair now assumes the role of the chair. So that's how, that's moving forward. Now, how do you fill these vacancies? For your congressional district representatives, the answer is set out in your bylaws, as I see it. And I'm looking at Article 3, Section 10. And this again in a resignation situation. It says if a congressional district representative resigns or is so removed, then the EC, that's your body, must replace him or her with a person residing in the same congressional district who shall serve until the next state convention. And your next state convention, as I understand, is July 9. At which time the caucus for that CD shall select a replacement for the balance of his or her term. So that to me is pretty straightforward in how you deal with a vacancy for those 4. Now, if this body has or has not filled those vacancies, I frankly think that's irrelevant. Your convention, according to your bylaws, says who shall serve until the next state convention, which is, again, as my understanding, is July 9. So I think from a matter of practice and procedure for those CD reps, your bylaws are pretty straightforward. Are there any, I guess I can take questions later. I'll just keep going. But now for these, I guess we have 2 officers that have resigned. Your bylaws aren't clear at all, frankly. The Michigan Nonprofit Act says that, as set forth in your bylaws, the board fills the vacancy, your body, the remaining fills the vacancy. Your corporate bylaws says it defers to the LPM bylaws. So they're not much help. Your LPM bylaws then say they address a removal, a vacancy in the context of a removal. And again, I'm looking at Article 3, Section 10. It says if they talk about removal and they in your removal, you can remove anyone from the EC who misses 3 consecutive meetings or fails to perform his or her fiduciary duties, whatever that means. It says may be removed from the EC and replaced by a 2/3 vote at a regular meeting of the EC. Well, that hasn't happened. Or a majority vote at convention following a motion for a vote of no confidence. That hasn't happened. Then it says if the chair is so removed, again, that hasn't happened. It says the first vice chair shall assume the chair and a new first vice chair elected. Well, that hasn't happened. So your LPM bylaws don't talk about what happens when you have a resignation. So then I'm thankfully your bylaws do have under legal and parliamentary authority, they do default, which is very customary in these matters, to default to Robert's Rules of Order. And you basically get the whole body of law of the of the current version of Robert's Rules. And you adopt that, and you've done that with your LPM bylaws. And here's what I've been able to find with respect to vacancies under Robert's Rules. Robert's Rules talks about the power to appoint means, in some part, it says the power to appoint means the power to fill vacancies. So, and then it talks about Robert's Rules says, well, so that would be your convention on officers. But then it says in between conventions, it's the EC that does the power of appointing. But then doing further digging, in 2 sections of Robert's Rules, it says, and I know this is being recorded, so I'll give you a cite. There's 2 sections of Robert's Rules, and when they went from the 11th to the 12th edition, they did things on paragraphs. They did it's almost like a Bible here. It's the book of 56:32 here. It says, unless the bylaws clearly provide otherwise, notice of filling a vacancy in office must also always be given to the members of the body that will elect the person to fill it. Then it says, if the bylaws are silent as to the method of filling a vacancy in the specific case of the presidency, the vice president or first vice president automatically becomes president for the remainder of the term, and the vacancy to be filled arises in the vice presidency or lowest ranking vice presidency. If, semicolon, then it says, if another method of filling a vacancy in the presidency is desired, it must be prescribed and specified as applying to the office of president in particular. And then Roberts says, in the case of, again, it's consistent, it says in another place, it says in the case of the president's resignation, death, or removal, the vice president automatically becomes president for the remainder of the term unless the bylaws expressly, and they put expressly in italics, which means they're really stressing it, provide otherwise for filling a vacancy in the office of president. So what that leads me to conclude is that you had your chair and your first vice chair resign. So then your second vice chair didn't resign. I hope that's true. Am I correct on that? Okay, good. Because then the rest of what I'm going to say isn't going to make any sense if that's not true. Then the second vice chair goes right up the flagpole and becomes the chair for the remainder of the term. And then you have elections for the now vacant first vice chair and the second vice chair positions. So that's what I've been able to determine based on a number of hours of looking at these various 4 items of authority here. And again, your LPM bylaws are your that's your main document, but they do incorporate Roberts. And parts of these bylaws could use some work, like for example, in our current dilemma of what the hell happens when someone resigns. But parts of it I really like, because I don't know who put these together, but parts of it I like, particularly where it says that the EC is going to be the state central committee. And there's some places in here that basically says, recognizes the legal precedent that state party rules and bylaws supersede statutory impediments to their exercise of their political associations. So I like those parts. But at any rate, but when we defer back to Roberts, that tells me where what your next steps are. Now, I don't know notice requirements. I don't know what your convention notice requirements are. My guess is your call has already gone out. I don't know if these resignations were included in the call. I don't know if your call says, in the transaction of such other business that may lawfully become before the convention. I know this is your candidate nominating convention. But at any rate, well, I'll stop there. And I've hopefully answered a lot of things. I didn't go through those questions specifically. I think I've answered a number of them with my remarks there. There may be some fineries that I haven't answered. But I'm sure between the 10 of you here that you'll remind me if I haven't. So with that, I'll just stop and take questions.
Thank you very much. So I think our methodology was prescribed by the roll call order. So I think we did our roll call starting straight down the district numbers. So I believe that would bring us to start from our districts and count up. So District 1 would be Ryan Roberts. Do you have any questions? You have a 10-minute allotment that you can ask back and forth if you have any specific questions.
Sure. So just based off of what you said, Mr. Doster, we did do a call to convention prior to the resignations of our chair and our first vice chair. And essentially that didn't give us a window of opportunity to add the resignations into the call to convention to hold an election for those officers. Assuming that what you're saying based off of your opinion of reading our bylaws and Roberts, Andrew he's our second vice chair, has ascended to the chair position. I guess I'm kind of confused on how we can hold an election if we didn't add it into our call to convention. Do you have any input on that?
Well, Roberts is famous for custom and practice. I used to use that when there wasn't a great answer in any of my organizing documents. Do you have a custom and practice of adding things to an agenda at a convention, or no? Or do you guys, if it's not on the agenda, you say the hell with it, we just not going to address it? Did that question, I guess that was for everyone, not just for you, Mr. Roberts.
Real quick, we don't even issue an agenda until a couple days before the convention. So the call only includes the date, time, and location, and that's what's specified in the bylaws. And that went out 30 days prior. So we've never announced business for the convention until a couple days prior.
Oh, so you could, Mr. Ellison, again, I'm not trying to put anybody on the spot here. I'm just going to ask. I'll ask everybody, but so you could on your agenda then add elections for first vice chair, second vice chair to fill those vacancies. And then also you could tell your what do you call them, congressional district groups, your CDs, your, what do you call those? Your congressional district groups that they are to elect those 4 district vacancies. There's still time to do that.
Yes.
Oh. Okay.
Yeah, we have not officially released an agenda. I think we're still in the works of actually finalizing our agenda. So that has not been completed yet.
Oh, okay.
I guess I can't think of any other questions off the top of my head. I can go ahead and yield the rest of my time.
All right, thank you, Ryan. So moving down the list of our leadership, I know we have District 2, Mr. Fox, who is absent today. That would bring up next District 3. Mr. Martin, do you have any particular questions that you would like to discuss?
You're on mute, Jordan.
I know, I realize this. Going through questions I had with what I got, and I might ask you to repeat some of what you had said, Mr. Doser, as I got booted for part of that. Zoom booted me, not Andrew, for clarification. I guess let's start off with, in your opinion, like professional opinion, what do you think your services could offer to the LPM and LPMAC as a whole in their current situation, or in our current situation with all of this?
I'm sorry, what's the question?
What do you feel like as though your services could like benefit the LPM or the LEC as a whole with that?
Well, since I've basically given you the blueprint of what you guys should be doing next, based on, again, outsider, impartial, never met any of y'all. You know,
That's in regard to continuing.
yeah, I know. I'm just saying that, you know, you need the parliamentarian to work through the election. And I guess as questions come up, I don't see a big role here, Mr. Martin, frankly. At first I was thinking 10 to 15 hours to go through it, but hell, my wife has a cottage in Lake Michigan, so I was out there and I was a little bored, so I started reading through all this crap. So I basically done quite a bit of it already. So I'm a geek on this stuff anyway. It's pretty fun. And I think whatever the bottom line here is, whatever your convention agrees to, you know, from a legal perspective, it's unassailable. Because the first and foremost, I don't care about the Michigan Nonprofit Corporation Act, but although you are complying with it, but remember, you're a political party and you have rights of freedom of association. So if you want to say that this person's this officer, this person's this member, or this person isn't a member, I wouldn't suggest you do that, start excommunicating people. I mean, I did that very sparingly in my years. I mean, you know, the KKK people running as precinct delegate, yeah, we had to get rid of them. But beyond that, you know, I mean, your freedom of association, your rights of political expression, you know, and it's hard, and you can't get any higher authority than your convention. So if your convention goes through and elects your new first vice chair, your new second vice chair, your congressional districts do fill in their representatives, and then the convention ratifies, I would also suggest that the convention ratify, you know, the appointment of the second vice chair to the chair, should he so choose to accept. And that wouldn't be a vote. I would just ratify it. And then it's unassailable. It's not going to be undone from a legal perspective. So I don't know, Mr. Martin, you asked, I mean, as things come up, I can't see you really need a parliamentarian, someone understands your custom and practice. Because as you just heard, I didn't even know that your agenda wasn't out until Mr. Ellison said something. So now that I know that you can craft your agenda at this late hour, that's great. Because then you can put in these elections.
Mhm. All right.
So anyway, as questions come up.
Okie doke. I guess follow up to that then, what is the potential gravity of the situation if you or a parliamentarian are not retained further after this? Just to go through all the possibilities of like what potential bad things could be.
If your convention approves everything, you don't need me or a parliamentarian. Again, your convention is your highest order. I mean, your convention selects you.
Mhm.
Your convention can get rid of you. You know, and I know there's some language about in Article 3, Section 10. It says a majority vote at convention following a motion for vote of no confidence, but it says or fails to perform his or her fiduciary duties is the trigger. I'm assuming you haven't missed 3 consecutive meetings. That to me is the guy wears bow ties and he's violating his fiduciary duties, or he's got blue eyes, or he's got brown eyes. To me, that means nothing. I don't know what a fiduciary, I mean, that's really a political question when it comes down to it, to be determined by your convention. So again, the point being is that if you don't have me or a parliamentarian and your convention decides X, Y, or Z, that's it. I don't see any, there is no higher authority than your convention.
And then does that include if they say like F the bylaws for a minute and we're gonna do this?
Well,
Like,
you can't.
we
suspend
generally follow
bylaws.
them, yes.
Right, well, that's, I
Like,
guess that's a
if it's
point
not to
where,
be followed during.
yeah. I guess that's a point. I guess you need help getting to that point. But as these things may arise, because you never know, there's always someone in the crowd that wants to make a statement that's not necessarily beneficial to the goals of the organization. Been there many times.
Mhm.
But I guess I would definitely have, I would have both if it were me, but that's your decision. I'm just saying that if you can get to a point where your convention does X, Y, or Z, then that's unassailable.
Okay.
So maybe you need help getting the convention X, Y, or Z. Then that's a different question than what you asked.
All right. I think that answers anything that I had, and then I yield my time.
Okay, thank you. So after District 3, would come to District 4. Mr. Stalen is not present today. Going on to District 5, Mr. Canning.
Thank you, and thank you for being here tonight with us. I appreciate you taking the time.
Oh, you're welcome. This is fun.
Really, I probably just have one, and it relates to something that's been touched on a little bit. There was some email back and forth with you and Mr. Chatterton regarding the motion of no contest, of no confidence. And there was a question under Michigan not-for-profit.
Yep. I got it here.
Could that motion be objected to by a delegate based on notification?
Well, okay. That's one question I didn't answer. Thank you. I'm looking at your LPM bylaws, Article 3, Section 10. It says, I'm going to paraphrase a little bit. It says the member of the EC may be removed from the executive committee and replaced by a 2/3 vote. It says at a regular meeting of the executive committee or a majority vote at convention following a motion for a vote of no confidence. Then the next sentence, and I think this is where this question comes up under the Michigan Nonprofit Act is going to defer to the bylaws first. So that's why I'm reading the bylaws. Then it says, all executive committee members must be notified of the intent to remove at least 14 days prior to the meeting. Doesn't say prior to the meeting or convention. It says prior to the meeting. So do we, if it said meeting or convention, then I would say, yeah, someone could object, but it doesn't say or convention. I mean, in the previous sentences, as I just read, it talked about both meetings and convention. But in this sentence, it says, all executive committee members must be notified of the intent to remove at least 14 days prior to the meeting. So my answer to this, if you didn't receive previous notification at a convention, I don't think that's relevant. That would be my, just reading it. Now, what would happen if this was in the convention setting? You'd have a parliamentarian there. This kind of gets back to Mr. Martin's question. You'd have a parliamentarian who'd sit there and, you know, agonize over this. And hopefully they'd have as much notice as I did, because I had a chance to read the question in advance. And then under Robert's rules, the parliamentarian makes the recommendation to the chair. And then the chair then makes a ruling of parliamentary procedure. And then the convention would have to defeat that ruling, you know, would appeal the ruling of the chair. As I recall, it takes a bare majority. So, so that would be that process. But if I were the parliamentarian advising the chair and there was a motion of no confidence at a convention and it wasn't given 14 days prior to the convention, then I would say it would still be in order.
And if it was provided 14 days in advance, there's no question it would be in order.
Well, right, then we would have to worry about the terminology about meeting or convention. The fact that the phrase or convention is conspicuously absent from these bylaws.
Okay, thank you.
Mhm.
And I'll yield the rest of my time.
Okay, after Mr. Canny, the next district with a present member is number 7, Mr. Ellison.
Yes, to reiterate what Dave said, thank you very much for your time. Appreciate you being here and taking the time over the weekend to avoid your wife and do the geek stuff.
She's on the beach.
Oh, okay, good. Real quick, because you touched on most of the stuff that I was going to ask. The parliamentarian sent over one question. The vast majority of his questions were about the vote of no confidence. And I'll have a question about that in a second. But his last question was about a notice, and you kind of touched on this. He said, how does Article 11, Section 1 affect the notice requirement in nonprofit statutes? And I would just like to hear you reiterate, I guess, the fact that you said that the nonprofit statutes are going to defer to our bylaws, and the fact that our bylaws explicitly say that we are not required to adhere to the statutory provisions that we don't voluntarily agree to adhere to.
Yeah, that's an election law purposes, but basically, I could come at this in a number of ways. I mean, that LPM has an absolute First Amendment right to determine its own membership and put qualifications on that membership. And again, that's why I said, and I can't remember whose question that was. I guess it was a Mr. Martin's question about if the convention says X, there is no higher authority here. No court, no statute. The convention is your highest authority. So, you know, I know that one of the questions here was, and I hope I'm answering your question, Mr. Ellison. One of the questions that the parliamentarian said about, do you need to have a trial or an investigation committee? No, I don't see why you need an investigation. I don't see why, again, your bylaws say fiduciary duty. Whatever that means. The guy wears a blue bow tie. I don't know. I really don't know what that means. And of course, when you debate the motion before the convention, you would, someone would point out, well, the bylaws say that Brutus here can't be removed unless he violates his fiduciary duties. What fiduciary duty has he violated? And but I suppose the convention could say, is that the convention would say, well, wearing a blue tie, they probably wouldn't phrase it that way. But what I'm saying is there's an awful lot of leeway. And so I don't think that the rigorous requirements of you need to have an investigatory committee or an investigation, preferring charges and holding a trial. I think if you get a thumbs up or a thumbs down from the convention, that does it. So I hope that answers your question. I'm not.
It does in a roundabout way.
Okay, sorry.
Yeah, I was asking more specifically about the notice, but I think you've already addressed it. So I was more or less asking you to reiterate it.
Yeah.
But this kind of leads me into my next question. So if the body successfully passes a motion of no confidence to remove the chair, then it's obviously in the body's interest to have the chair removed, right? And if the body does not succeed in the motion of no confidence and the chair remains, then there's no question we don't have to worry about any of these other issues that the parliamentarian was asking you about, how you deal with this vote of no confidence, right? So
Well, yeah, if a motion's brought forth, again, if I were the parliamentarian, 14 days or no 14 days, I would recommend that be accepted. And then if the chair doesn't want to have this motion and says no, it's out of order, because they're reading the bylaws to say 14 days prior to the meeting and convention, or includes the term convention. I mean, from a political standpoint, let's look at this practically now. If the chair's got the votes to defeat that motion, he's got the votes to defeat a vote of no confidence. So it doesn't, you know what I'm saying?
yeah,
Sometimes these things, hinge upon the practical or the realistic.
right. So I guess the question about how this vote of no confidence proceeds or can't be proceeds or can be objected to, none of that really matters in essence, unless the body actually takes those steps to actually do it.
Correct.
So my question is that since it's only in the interest of the body, if he is removed, to remove him, is it a conflict of interest for this board to retain a professional such as you or such as a parliamentarian to work in defense of that motion that would be against the will of the body?
Well, that's an interesting question. I've pretty much laid out the procedure. I don't know what I would change. So is it a conflict of interest? No. Y'all, every political party has a general counsel, and well, I guess you guys don't. You guys have do you guys have a formal parliamentarian that you have? That's
No.
interesting. Because typically, whether it's from the congressional, county parties and up, everyone's got a parliamentarian, and a lot of county parties have their own counsel. I've never heard that of being a conflict of interest in that context. So I'm gonna have to respectfully answer no, because that person is supposed to, fairly interpret the bylaws and whatever these other items of authority. And so no, I don't see that as a conflict of interest. frankly.
Okay, so then my last question, and you said that whatever, I don't know if I'm going to get your words right, but you said basically whatever the convention body decides is unassailable.
I agree.
So if the convention body decides that it's in order to hold a special convention, if necessary, or to amend the agenda to include officer elections, if the body decides that by a vote, the body rules, is that correct?
Except if it's contrary to the bylaws. And so I've gone through your bylaws and incorporating Robert's Rules of Order. So in other words, because you can't suspend bylaws. I don't remember where that is at Roberts, but I know that I've had that question come up many times over the decades. So in other words, let's say that the convention said we have to have a chair election, and they want to put that on the agenda. That would clearly be out of order, and then the chair could refuse to recognize that motion, because that wouldn't be permitted under the bylaws. And your bylaws are very clear that they can only be amended in odd years, which frankly is something I like. I like that provision, because in the even numbered years, you guys shouldn't be screwing around amending bylaws. You got more important fish to fry. So I really like that provision about you can't amend bylaws. So if the convention, this maybe I'm answering this question more than you've asked, but I suppose if there were a majority of the convention wanted to press forward, boy, that would be chaos. Again, I'm using the example of a chair election, because again, that's not allowed under the bylaws. If I guess the chair could gavel the adjournment of the convention, and then there would be kind of a mess, because then the convention wouldn't have acted, and then what would you have left? I mean, I would hope it wouldn't, you all can agree more than that, but that would, then you hear the term RUP convention or rump convention, whatever the hell that is.
Real quick, because I think I have like 5 seconds left. Are you
Okay, sorry,
suggesting
I'm
that,
going on.
no, it's okay. Are you suggesting that the chair can adjourn the convention without the body's authority?
Well, I guess if they were trying to do something contrary to the bylaws like this, I think that's something that the parliamentarian should look at. So I'm not prepared to answer that tonight.
Okay, thank you very much for your time.
All right, thank you for those. Our next district with someone present is District 9, Mr. Saliba.
I think we already pretty much summed this up, that, the convention is, all that really matters and such. I guess just my kind of like short question is more of an opinion question. We've been doing these things for 50 years. We have members who have been to all of them. We have members who have been to dang near all of them, who are lawyers and have been general counsel to our national party. And we've never, not in the time I've been around, had a certified parliamentarian, but we always have somebody we call the parliamentarian because they just know a heck of a lot about Robert's rules. And that's served us in the past. Is it just kind of your opinion that it's worked, it's going to keep working, we shouldn't be too worried about anything right now?
Well, I definitely have someone serving the parliamentary role. So if you've got someone who's done that before, who has seen your conventions, who has participated in your conventions, I would definitely, I think I'd be a fool to recommend anything else, that you'd have someone, you need someone in the parliamentary role, because a lot of times these things come out of left field, these questions, and you need to hit the pause button. Someone who's, oh yeah, we did this 5 years ago. We did this 10 years ago. Those people are invaluable. So if you have someone that can do that role, I would definitely encourage that. I'm being
And-
Captain Obvious. I apologize.
Yeah. And just, it sounds like you spent a lot of time with the Republicans. I'm sure you're tangentially aware of any goings-ons with the Democrats as well. Have you ever heard of any kind of legal action taking place because of a state convention like this, or anything to do with nonprofit bylaws versus?
Never. You got to go back to 1988. I became Assistant General Counsel for the MRP in 89. So I was just after in 88. That's where a lot of these cases come from, that I know were cited here in your bylaws. There was the Heitmanis versus Austin case. That was, yeah, the U.S. Supreme Court ruling in Yo v. San Francisco. That it's been a while, and basically what arose out of those cases were the party rules. That was a little different because there was a discrepancy between what state law required your membership to be and what the state party rules or bylaws required. So I am answering your question, believe it or not. So I've seen convention litigation, but it's been state law versus state party rule or bylaw. It hasn't been where the convention kind of disintegrated, if you will.
Aggrieved members or opposing parties?
That hasn't, yeah, I haven't seen anything like that in any party. Again, 88 was probably the closest to your question, but that was a different issue. So, and I know that was it back in, what year was that? That would have been back in 1996. I don't know if this answers your question, but I'll start it telling it. Back in 1996, there was it was Buchanan versus in the Republican presidential, Buchanan versus Dole.
Dole.
And the Buchanan people stole some Dole delegates in the congressional district ranks. So John Engler said, okay, you stole two Dole people. We're going to call two Dole people Buchanan people. and they elected them out of the at-large delegation. Now there wasn't judicial litigation on there because it wouldn't have gone anywhere. There was actually a judicial-like hearing before the Republican National Committee. And I don't know if you have those kind of processes here where we would go up to the National Party and have them decide, who the proper chair is, who the proper officers are. But as far as litigation in court, no, it might have to go up to the National Party. That's what happened there. I had a trial. So, and I got to argue that one, by the way, in San Diego. It was great. I was sitting there and it was like never mind. I'll tell you later. I'm getting too many war stories here, but it was fun.
All right, no problem. Thank you very much. I yield back the balance of my time.
Thank you.
Thank you. Mr. Brungart, that'll bring up to you next.
Okay, you're gonna have to forgive me because I've been taking so many notes. I haven't really been thinking about what questions I want to ask. Yeah, so now I don't know what to ask.
I would propose a few an account of your secretary duties if we could come back to you if no one objects. if you'd like.
Yeah, I would. Thanks, Andrew.
Sounds like nobody objected, so gonna go ahead and move on. Mr. Chacase, would you like to ask any questions?
Yeah, my elementary school PTA has a parliamentarian. However, our LEC doesn't have one, our convention doesn't have one, and the motion to get a parliamentarian has been voted down. And after coming back from Reno, I see the total value of having a parliamentarian. And so before Saturday, how do the bylaws or anything say, how do we select this parliamentarian? You know, there are people who, you know, are parliament, have knowledge of or rule meisters, I call them. And there's, you know, they're right here on a lot of them. And I also joke to my daughter that all libertarians are parliamentarians. But so how are we supposed to, are there anything in the bylaws about us selecting a parliamentarian before Saturday, start the meeting off without having like a knife fight on the floor or something?
I can answer that from bylaws and I think Robert's perspective, if you have it. So generally speaking, the Robert's rules provide for the chair to select a parliamentarian for business. However, that's further constrained by the authority to expend or spend money. So the current situation for us is the discretionary funds, which have been utilized for some of the initial opinions from the parliamentarian are looking like they're currently exhausted. So the only opportunities for funding at this point come from this board as a whole. So if we would like to consider such, we would need a noticed motion passed by this board prior to convention to authorize the expenditure to have one.
Okay. Also, so how would on the agenda would we have like the no confidence vote first, or have the other elections second? I mean, because now are the chair and the new new chairs elected by the body, or they also or by the executive committee? So I was slightly confused, like, you know, does the body elect the new chair, or is it by the executive committee? Because it's not like if it was done, if they had left before the meeting, or, you know, like if we had removed them or something, then the executive committee would then appoint the new, you know, chair, first chair and second chair. But now we're at the convention, so would that still be the executive committee doing the voting, or is that open to the whole convention?
Well, again, there wouldn't be any chair election as I read your bylaws. I suppose you could have this body could, I mean, you don't have much time. I suppose an argument could be made that this body, because your convention's not meeting today, could elect a new first vice chair and second vice chair to serve out the balance of the term. And not allow the convention to do that. However, I'll put on my political hat on right now. Would that be a wise thing? Although I think you have that authority, because the executive committee, I know I read somewhere in here that you can act for the convention somewhere between meetings of the convention. But, you know, how many days notice do you have to give to have an EC meeting? What, 2 days, 3 days?
Correct, 2 days.
You know, 2 days. So So the earliest you could have, you'd have an EC meeting on the 7th to elect the new first and second vice chair and preclude the convention from doing that. That's your political call. I don't know if I would do that. And I'd every once in a while, you gotta let the convention, you gotta make it meaningful for these people to show up. And again, I'm not giving you legal advice now. I'm giving you decades of what I've gone through with the Republicans. You give them more to vote on. The less you give them to vote on, the less they feel the need to come to conventions. And your goal is to get people to come to conventions. So I would suggest, not from a legal perspective, but from a practical one, that you have your first and second vice chair meetings or elections at the convention. I don't know what you're talking about, this I don't understand it. There is the no, are you guys planning on having an agenda item for no confidence? I don't know where that comes from.
There's
Yes. it's gonna happen.
there's been a notice sent to the board that a motion of no confidence will be presented at the convention.
I didn't know that. Okay. Okay.
So,
It sounds like that should happen after the election of the first and second chair or vice chair. Otherwise, it could put us in a situation with not having the ability to elect a chair.
Yeah, I guess. Yeah, then, right, because at that point, yeah, I guess, yeah, from a practical matter. Well, but then let's say you elect a first vice chair and a second vice chair. And then you have this motion for no confidence, and let's say it gets approved. Then your first vice chair is automatically gonna be the chair for the duration of the balance of the term. So then, is the convention going to accept that? Or, I mean, they just elected this
Well,
person.
technically speaking, the officers don't even assume their roles until the close of the convention anyways. So we still technically wouldn't have a first or a second vice chair until the close of convention.
Oh, that's right. Yeah, you need someone to figure that one out, but your parliamentarian should look at all that and the ramifications.
I yield my time or whatever.
Okay. So that brings us to the end of the district reps, and I had jumped over at the beginning of the meeting of the officers, and that would bring us to Norm. Mr. Peterson, do you have any questions you'd like to ask?
I have no questions that have not already been addressed,
Okay,
so I yield the rest of my time.
so that brings us to the end of our Q and A's.
Unless we were going back to Joe.
I'm sorry, you're correct. Joe, you were passed over and have the opportunity to ask any questions.
Okay, I've had a little bit of time to try to think. I don't have any questions. I just would like, similar to how some other members have, just maybe to reiterate my understanding, and if you could either just say, hey, that your understanding is correct, or add clarification, or tell me, no, you're an idiot, you're wrong. So my understanding is our bylaws, since we don't expressly have a way to fill the vice chair openings, that it is up to the members, and if the board wishes to add these items to the agenda based on our practices of setting the agenda a couple of days before the convention, we can choose to add the vice chair elections to our new business. And there really is no discrepancy in our bylaws that would prevent that.
Right.
Okay, thank you. Yeah, that's pretty much it. Like everybody else said, though, I do want to thank you for your time, and I appreciate the fact that, even though you're a geek for this stuff, just like the rest of us. I appreciate the fact that you put in a little bit more time than what
A
we
lot
actually.
more time, but I enjoy it.
Yeah. Yeah, a lot more time than what we actually authorized to pay for. So again, thank you
No
and
problem.
appreciate it. I yield.
As we're closing that out, perhaps on behalf of the questions from the parliamentarian, since he's not present and those were considered, can you confirm kind of the understanding with the applicability of the Nonprofit Corporation Act that that would be secondary in any case
Yes.
to the LPM bylaws and
Yes,
the documents they provide? Okay.
yes,
And then that the Michigan Nonprofit Corporation Act would not overrule any of the provisions from bylaws or from Roberts with regard
Correct.
to the disciplinary removals, any of that stuff, or notice requirements.
correct.
Okay. Thank you very much. So I think that is everything for the Q&A portion. So we have on our agenda the motion to consider additional authorization for hiring more time. Did you have some further, Mr. Duster?
Do you want me to be excused or leave the meeting now? Or are people gonna have questions that are
Let me
relevant?
see. I think we would be set in that regard. So
Then I
I'll
will,
follow up with you to arrange for the 2 hours and everything to get you set for that and
Yep.
close everything out in that regard. And then I'll let you know.
Mr. Chair, Mr. Ellison has his hand raised.
Yes, Mr. Ellison,
You're muted.
you're muted.
Sorry, if you need to dispose of whatever with Mr. Doster, I don't know that we need him for the balance of the meeting.
Yeah, I think we're all set. Thank you very much for your time and appreciate
right.
your help.
Yeah,
thank you.
thank you
Good
very
luck
much.
with everything.
Thank
Thanks,
you.
Eric.
You're a
Thank
big
you.
help.
Okay. So
Um,
yes, Mr. Ellison, go ahead.
I move to rise from executive session to general session.
Second.
Do we have any discussion?
Just point of, I don't know, procedure. It's not parliamentarian. Zoom procedure. Should we stop the recording and create a new one so that the new one gets posted?
Yes.
I was thinking exactly that. So I will stop the recording now and then I don't know how Zoom handles things, so I think for best measure, I will try to download the existing one so that we don't lose it. I don't know if that would be overwritten by starting
Someone else
new.
record it and email it.
I can log in and download the
Okay.
recording we've just about to complete. I'll stop that in just a second. Let me get this ready to go and queued up so I can, I don't know if that's gonna be practical. So, would it work if I create a brand new meeting and I'll share it in the chat here? We'll end this one and we'll pick back into that one as a continuation of this meeting. Is everyone okay with that approach so that there's no risk? Because I know the recordings have to process for a short time, so it won't be immediately available that I can start the new recording.
Yep, I would, if I could, Mr. Chair, I would request just like if we adjourn, just a 5-minute we don't adjourn, we recess for 5 minutes and return at the new Zoom location.
Yes. Is everybody good with the Zoom, new Zoom link being posted in the Discord chat room? For XCOM, we'll post our general session there, and I can also throw it in the general if any other members happen to see it on the short notice.
Can we put it in this chat?
We can do that as well. Give me one quick moment. I will create a new meeting. And then I'll stop the recordings and proceed from there. All right, this is gonna be scheduled for 8:30. That's passed already, but it's gonna just for the technicality of existing, it'll say 8:30. All right, it is in the Zoom chat.
Make sure you copy and paste it, guys, because it'll disappear as soon as we leave.
Right.
It's also posted in Discord on both general and XCOM chats. Okay, I'm gonna close the meeting, stopping the recording, and then we'll resume we're recessing as long as there's no objection until we reconvene and call back to order in the new Zoom meeting. Any objection to that motion? I'm taking that as assumed at this time. Please object if you so feel that. Hearing no objections, I'm assuming that is passed, that we'll recess until we reconvene in the new meeting.